what are the advantages of mediation? Well, firstly, it's a confidential process. It's undertaken on what's called a without prejudice basis. And that really means that whatever goes on at mediation stays at mediation. Anything disclosed or discussed can't be used outside of the mediation, so can't be held against the party then if proceedings are necessary. And the intention there is to ensure that the parties can both come to that process in good faith and be realistic about the ways of settling the dispute. As I mentioned, there's no obligation on the process. The parties have to agree to it, and there's no obligation to do anything once you're engaged in the process. If it's not going how a party wants, or if it doesn't seem that an agreement will be reached, either party can walk away at any time. It's a non-obligation process. That said, if terms are reached and if an agreement is arrived at, normally a mediation will conclude with a mediation agreement. And that summarises the terms that the parties have arrived at and becomes contractually binding then on the parties. That will effectively end the dispute. We remove the need for court proceedings, and whatever's agreed is binding on the parties. Now, a huge other advantage with that is that it affords great flexibility. There are things that courts can't do. There are orders they can't make, there are arrangements they can't put into place. The advantage of a mediation is anything's on the table, and certainly we've assisted on matters where commercial disputes have been settled by bringing in other relationships that the clients have on different projects or on different work environments, and brought those in as a way to broker a settlement, which is simply not something a court could do in a claim over one dispute.